the topics that we're planning to cover are hopefully on your mind. We want to talk about the new border control measures, limits on asylum, a new program for workers, for worker protection, and also the upcoming DACA decision.
So just before we start, I'm going to introduce ourselves and apologize if this already happened and I couldn't hear the volume. My name is Ariel Gould. I'm the supervising attorney for Make the Road New Jersey's immigration team.
And I'm Lauren Herman. I'm the legal director at Make the Road. I think impact the end of Title 42. Awesome. That's our first topic. So I think a lot of you may already be familiar with us, but Make the Road is a community-based organization, a membership-based organization. We support immigrant and working class communities to achieve dignity and respect through community organizing, high-quality legal and support services, policy innovation, and transformative education. We've included our Facebook and our Twitter and Instagram and all that good stuff. Hopefully you'll follow us. Both for your own information and also, to share with some of your students. We're always trying to post as much information and know your rights as we can.
So services, I think we talked about it briefly, but services that we do offer, we have legal and health services. We do a lot of clinics for, Medicaid, for the, I'm thinking of New York topic of it. Cover all kids. I was like Child Plus, but they cover all kids enrollment. We have clinics for that. We do legal services. We have workers' rights, housing rights, and immigration. We have ESOL classes for free. We do driver's ed, citizenship classes. We have a leadership school. We have a student success center for children that are children, young adults who are looking to enter college. And we do community organizing, and our community organizing in particular is really based on what's going on and what the community members are seeing and need. So we have committees that are member led or that have a huge membership base in Perth Amboy, Passaic, and Elizabeth. And they talk about different topics that are ongoing, different needs that they have. And then that gets communicated as well to our legal team and informs a lot of our work. So it's kind of this back and forth and hopefully a helpful cycle between legal and our membership and our community organizing. And then we do advocacy on a state and national level for the policies that would help our community.
Okay, great. Oh, and we have an immigration attorney joining us. Awesome. Welcome. You'll have to chime in if you can. So to share some of our campaigns and victories from the past several years. So we were first established in New Jersey in 2014. We've been very busy and we've actually grown quite a bit in the past few years. Over COVID, we were really lucky, but some of our campaigns include winning a $15 minimum wage in New Jersey. That includes teen workers who were originally carved out of the bill. During COVID, we won a new policy to get occupational licenses, professional licenses for everyone, regardless of immigration status. So it was news to me that there are over 200 professions in New Jersey that require licensure. And so now after we won this new bill, anyone is eligible to apply for those licenses if they have the proper training. And their status shouldn't matter. So I know there was a question in there about working. The occupational licenses is a really important tool for people who are not work authorized to be able to find ways to support themselves. We won wage theft protections. We actually most recently won the Temp Workers Bill of Rights, which isn't even updated on this slide. Universal representation for immigrants who are detained, state financial aid. We have the first ever Student Success Center in New Jersey here in Elizabeth. Driver's licenses, I think that was maybe our biggest win. The millionaire's tax, and we're constantly growing and expanding and expanding our campaigns based on the needs of our members, as Ariel said.
Okay, so now transitioning to, I guess, the meat of our presentation, which are these recent updates on immigration, and we're screening the questions as we go through. We'll address, I think, some of them later as they come up. They're not technically covered here, so we can kind of talk about them a bit at the end, but just talking now about the kind of the topics of the day or what we're seeing come up a lot. One is the end of Title 42. So I think a big question is, what was Title 42? I feel like it's been a lot in the news. I think there's a lot of misinformation about it. So basically Title 42 was called Title 42 because of the code section that this like power or supposed power to do this came under. And what it was saying was that people that had been in a country with a contagious illness, and this particularly COVID-19, saying they could not enter the US because of alleged public health concerns. And what it resulted was in this really quick expulsion without the right to fight their cases, without the right to see a judge, of large numbers of individuals directly outside the US without being able to fight their immigration case. And this is particularly people that were coming from the southern border and were caught trying to cross.
And I think that, there were certainly people who have been coming in, and maybe you've been seeing recent arrivals in some of your classes, but the basic effect was that the border was essentially closed throughout most of the pandemic to the majority of people who are trying to come in. And so, as Ariel mentioned, Title 42 was originally invoked by the Trump administration at the beginning of the COVID pandemic. And again, it was alleged to be for public health rationales, but in reality, it was just an anti-immigrant measure and a way to keep people out. There was a lot of disappointment when the Biden administration took over and did not immediately end Title 42, but continued to use the policy to expel immigrants, and also expanded the use. So that was really disappointing.
And so Title 42 ended with the end of that declared emergency at 11:59 p.m. on May 11th. And there was a lot of talk and a lot of news coverage about what this meant and what it could mean and what it would mean for people trying to enter through the border, the number of migrants coming, all of that. And unfortunately, what the response was from the administration was to essentially create a new program that largely continued and expanded on what Title 42 was doing. And then they coupled that with additional limitations on asylum seekers while creating a couple of lawful pathways for people to come. But largely it just resulted in additional limitations and actually stiffer penalties for individuals trying to cross the border. So we'll get in a second to what exactly that was.
And I think a lot of this, right, there was a lot of panic, right? Like, the administration was responding to a lot of people who are expecting that the border was going to be completely flooded by people attempting to enter as soon as Title 42 ended. Now it's been about 2 weeks since then, and we have not seen any evidence of that. Right? There was not the massive influx of people that they were expecting. But as Ariel said, they did create this new policy, which significantly limits who is able to access the border.
So it's a new policy and this new rule in asylum that they called circumvention of lawful pathways, which is just really trying to funnel people through this very limited number of spaces and results in extreme prejudice to those that aren't able to follow them. So what does the new policy do?
Yeah, so the new policy has a couple different elements to it. So the first is they created this app, and the app was actually created before the end of Title 42. There was a lot of feedback that the administration got that it wasn't working. But the basics of it is that if you wanted to come to the border to apply for asylum, you had to request an appointment through this app. There are 1,000 daily appointments. And so what was happening is, like, all of these people were like standing on the highest hill they could find to try to get an internet signal to get an appointment. So again, under the new policy, the administration is saying, if you want to apply for asylum at the border, you have to do so through one of these appointments. One of the other, so they're saying we're creating these appointments, we're creating this lawful pathway, even though I think there are many significant and very realistic concerns about that. The administration also increased the number of refugees that the U.S. is supposed to accept every year. For folks who don't know, asylees and refugees are essentially the same group of people. They both have to meet the international legal definition of someone who has suffered persecution in their home country because of a protected characteristic or fears persecution. The only difference is that refugees apply from outside the U.S. and asylees apply once they've arrived to the U.S. So again, this is trying to encourage more people to apply from outside the U.S. and then come in, quote unquote, lawfully. In addition, the administration increased control at the border. They increased agents, and they authorized military personnel to go to the border and work with CBP. which is, again, problematic for many reasons. And then the last thing that is part of the new policy is increasing the use of expedited removal. So if somebody does not come through one of these designated pathways, they can be expeditiously removed without having a chance, without having a process, without being able to go before a judge.
Yeah. And one of the changes with expedited removal is specifically expedited removal is a form of deportation. And what they said is that people from, and a certain number of people now from Cuba, Venezuela, Nicaragua, and Haiti, Mexico will accept them as being deported to Mexico, whereas previously they would have had to deport them to the country of origin, which makes it easier for the expedited removals to occur. So one thing we do really want to mark what expedited removal is, because it sounds similar to what was happening under Title 42, but it is actually different. So Title 42 were expulsions. They were just essentially moving people outside of the country. Expedited removal is actually a process by which someone gets a removal or a deportation order with a penalty that lasts 5 years, where they're not able to come back for 5 years. The removal order can be reinstated, so it cuts off future opportunities to see a judge as well. And if you try to come back after the expedited removal order, then you're open to criminal penalties as well. So it is a very serious thing to have happen with, at least in my opinion, very little what should be necessary judicial oversight for the people that are coming through being expedited removed. So the increased expedited removals, the one way you can try to say I'm not subject to expedited removal or should not be removed expeditiously is by trying to say that you have this fear of return to home country. And then essentially you're trying to fight your case and show why it is that you should be allowed to apply for asylum. And if it's not asylum, it's two things called withholding of removal or protection of the Convention Against Torture, which have fewer protections. But one thing they are doing at the same time is increasing these expedited removals, is increasing the speed at which these screenings for fear occur. So in particular, people over 18 and who aren't traveling families have telephonic interviews to try to be screened for asylum, which creates a lot of issues in terms of presenting the claim, providing help, access to attorneys to be able to really present the fear, because asylum is something that's very, very confusing and hard to kind of present in the way that's most effective legally without legal assistance. And it creates this very, very quick process with very little opportunity to access counsel.
And, just to stay on that point for a moment, right? Those telephonic interviews are going to be happening while people are still in CBP or ICE custody. So I'm not sure how many of you have seen pictures or heard stories from your students about what CBP custody is like, right? Many people talk about hieleras, right? Like the ice boxes. They're in these horrible freezing cold rooms. People are often, I recently had a client who arrived, they didn't let her shower for 10 days. They've just gone through the trauma of trying to come to the US, and they're expected to now get on a phone and tell a stranger why they meet the legal elements required for asylum, which are, complicated on a good day for a lawyer to argue. So it's a really incredibly unfair and problematic process, as you can imagine.
So, I guess one probably good benefit that does come out of this new policy and they have been putting forward is these ideas of 2 parole programs. One is just general parole for people from Cuba, Haiti, Venezuela, or Nicaragua. And the other is this idea of family reunification for people from El Salvador, Guatemala, Honduras, Colombia, Cuba, and Haiti. So the parole specifically, it's 30,000 people a month from these 4 countries. What the parole is it is essentially the right to come to the US. So this is solely for people that are not already in the US that go through this lawful process that allows them to come. If they're granted parole through this process, they're able to come to the US for 2 years. And while they're here, they can apply for a work permit, but there are requirements. So beyond being from Cuba, Haiti, Venezuela, Nicaragua, and being outside the US, they also have to have a sponsor in the US. So this does not have to be a citizen or a lawful permanent resident, but it does have to be someone that has some form of legal status or quasi-legal status here in the US, and that has sufficient financial resources to be able to show they'd be able to support the person. And that's among other, basic screenings and requirements they have. So it is a good program. I do know people, there are people coming through this program, but it is limited both in number and requirements. The other they've started, and this is very, very recent, so we haven't really seen how this plays out, is this idea of family reunification. And they said this would be up to 100,000 people in total, What it gives is permission to enter the US and the right to apply for a work permit. And this is solely for people that have an approved I-130 petition. So the approved I-130 petition is an approved family petition, and where they don't have a green card available. So some family petitions, right, there's no, spouse of a US citizen, there's no wait list. But we all know that for others, like sibling of a US citizen, or like minor child of a lawful permanent resident, there may be a years-long wait list between when this petition is filed and when the person can actually apply for a visa to come to the US. So the idea is that some of these people that have these approved petitions but don't have a visa available to them would be able to come to the US. This process hasn't really started. What they're saying is they're going to start sending invitations to the Department of State in June. We don't really know what this means. We don't really know what it's going to look like. That's kind of the information that we have at this point, but it's something that should be getting updated as like June comes around, they start sending out these invitations and providing more information.
So in addition to all of the changes around border control that we mentioned, the new policy that the Biden administration put out also changes the process for applying for asylum. So there are two new parts of this policy, and they're saying that the policy is going to be in effect for folks who enter the US in the 2 years after the end of Title 42. So from May 11th, 2023 for the next 2 years. And I should add the caveat that that is if the policy does not get enjoined by the courts, which as we'll talk about, we are very hopeful that it will. So the two parts of the ban are essentially an entry ban and a transit ban. So the policy creates a presumption that if someone arrives at the US border with Mexico, who's a non-citizen, right, they won't qualify for asylum if they didn't try to enter legally, right? So through one of those legal pathways, quote unquote, that we mentioned earlier, through the CBP1 app, through a parole program, something like that. If they did not present themselves at the border with an appointment, or if they didn't apply for and be denied asylum in one of the countries through which they traveled. So this policy may be sounding familiar to some of you who are paying attention during the Trump administration, right? It is very, very similar to the asylum bans that the Trump administration put in place, saying essentially that for people who had traveled through other countries to get to the southern border, they were not eligible for asylum if they didn't apply for asylum in those countries, which again, we know is a farce, right? Like they're not going to be safer necessarily in some of the countries where people are traveling. There are some exceptions to these two asylum bans. The largest probably is for unaccompanied minors, right? Those are children under 18 who are traveling by themselves without a parent. And there are also exceptions if someone has, if they can show somehow they weren't able to use the CBP1 app, if they have a medical emergency, if they're a survivor of human trafficking. They're saying if there are imminent threats to their life or safety. I know most of the folks that we talk to who have been stuck in Mexico waiting to come in have imminent threats to their life or safety. So I am skeptical that they're going to allow all those people in and allow them to circumvent this policy, but that's what they say. One thing that I want to point out that many of our colleagues who work specifically with unaccompanied minors are very concerned about is that policies like this, even though we are absolutely grateful, it is absolutely the right thing to exempt unaccompanied minors from asylum bans like this, it ends up creating more family separation, because families who arrive to the border as an intact family unit are faced with a really difficult decision of either all of them being denied asylum or trying to send their children ahead of them without the grown-ups, because the children will be allowed in if they're on their own. So in our experience, we've seen that policies like that create much more family separation, which is really problematic. So if someone can't show that they're exempt from the new changes to the policy, they're allowed to have a reasonable fear interview, which is a a legal term. We try not to use too much legalese, but the basic premise is that it's a much higher standard that they have to prove. So currently, or previously, I should say, if someone arrives at the border, they have to show that they have a credible fear of persecution, right? Which just says that they are believable, right? That what they're saying, if they're saying that they would be persecuted, is believable. Now it's a much higher standard that they would have to show, again, in these pretty less than ideal circumstances, to be able to even have the opportunity to apply for asylum.
So, so yeah, it's one thing I do want, and I don't want to get too into the weeds, but just to note, because I don't want there to be like a takeaway that's kind of misinformation, is that if someone can't prove that they qualify for asylum, or that they like would meet this, like, this exception to being able to qualify for asylum under this presumed ineligibility, they can still try to show that what I mentioned before about withholding of removal or protection under the Convention Against Torture, which is a much higher standard, which is why you see this transition from a credible fear interview to a reasonable fear interview, and additionally have very different and much more limited benefits. It does not give route to legal status permanently here in the US, does not give route to residency, does not give route to citizenship,
or to bring in family members.
So what is being done now to stop the policy? I think, as is pretty transparent, we are both very concerned about what this policy is and what its impact is going to be on people that are coming to the United States in fear for their lives because of what is happening in home country and without somewhere safe to be in the in-between, right? And also the way it's going to be implemented. And quite frankly, I think probably unequal way that's going to be implemented depending on a person's circumstances and ability to advocate for themselves and probably their level of education. But so what's being done to stop it, which we're obviously in favor of, is there's already a lawsuit filed by the ACLU, the Center for Gender and Refugee Studies, and the National Immigrant Justice Center, trying to stop this new asylum rule. And we're hopeful. The Trump administration had tried to create very similar rules, not exactly the same, but very similar, around the asylum process and creating these barriers to seeking asylum or being granted asylum here in the US, and that was stopped by the court. So we're hopeful it will have a similar outcome now.
So what are we seeing here in New Jersey, and what are we doing at Make the Road? And we're also very curious, when we have time for discussion at the end, to hear some of your thoughts about what you all are seeing. I know some of you have already put in the chat some of the things that you're seeing from your students. So we are seeing more immigrants arriving from Venezuela, from Peru, from several other countries. We expect that there will be more as people hopefully are able to get these appointments that are like harder to get than Taylor Swift tickets. We are increasing our capacity to support recent arrivals. We currently, part of our services that Ariel mentioned in the beginning, we currently have vaccine clinics and also healthcare enrollment as part of the Cover All Kids program, which I realized actually we should have put in here as its own separate thing under updates. So maybe we'll add a little bonus slide too. Oh, can we slow down? Yes, sorry. Thank you, Eric. So we currently have vaccine clinics, we have healthcare enrollment clinics, and so we're going to hopefully be expanding those to meet the needs of new immigrants who are arriving. One of the things that we've been seeing is that a lot of recent arrivals need not just COVID vaccines, but all of the full suite of vaccines in order to enroll their kids in school. And so we're working with folks from the state to make sure that those resources are available. We're also working to prepare information sessions to welcome recent arrivals, provide information about life, key services, eligibility here in the US. And we're hoping to create these pop-up welcome sessions where once a month people can come and have a one-stop shop where they get all the information they need.
I think, do we want to stop at the end? I
think maybe let's just start everything. Okay. So the next update that we're going to talk about is the DALE program. It's Deferred Action for Labor Enforcement. I'm curious, folks could maybe raise their hands or put in the chat. I'm curious how many people have heard about this program. It is the culmination of over a decade of work by workers really organizing to demand protections. And the program creates a process for non-citizen workers who have experienced labor rights violations or who have witnessed labor rights violations to request deferred action. And the idea is to really protect these workers from immigration-based retaliation and to encourage them to come forward and cooperate with the Department of Labor, with the National Labor Relations Board. The first time you're hearing, awesome. So it's a really exciting new program, and it has been a partnership as it, between worker-led organizations, worker centers, workers themselves, and some of these labor agencies who know that it's super important for people to feel safe coming forward and report the violations that they've experienced or that they've witnessed, but that if they're afraid that their employer is going to call immigration on them, they are much less likely to cooperate. So deferred action is a type of protection that's been in immigration law for a long time. In various contexts. It's actually the basis of DACA, right? The program for dreamers that we're going to talk about in a second. What it does is it says that the government agrees not to deport someone for the period of the deferred action, which in this case and in many cases is 2 years. And you're also eligible to apply for a work permit. The way this process is working is that a worker has to get a letter of support from one of the investigative agencies that's working with their claim. So it could be a state, federal, or local Department of Labor, a civil rights agency that may have gotten a complaint about a workplace violation, the National Labor Relations Board. So those agencies are able to put out this letter of support saying that they are asking the Department of Homeland Security to provide this deferred action so that the worker is able to be here and be protected to participate in the investigation. So the program is very exciting. It's also somewhat limited and it's brand new. So we're not sure how it's going to play out. I'm actually hoping to send out my first application today, fingers crossed. And so one of the limitations is that it is only a 2-year program. Workers are able to renew at the end of the period, but it seems pretty uncertain what's going to happen if the investigation that forms the basis of their application has concluded, if they're still going to be eligible to apply to renew at the end of the period. So there's still a lot of question marks, but it could be a really important protection for people.
And so just moving on to DACA, which is another form of deferred action for childhood arrivals. And I will attempt to speak more slowly. If I don't, please message. I promise no one will be the first or the last person to tell me that I'm speaking too quickly. So please just let me know. So essentially, I feel like DACA has been in the news for years and years and years and years and years, from its inception around 2012 to like everything was happening under the Trump administration with the attempts to rescind DACA and cancel the program, and then continuing now that it continues to be a fight. And then so kind of what's the current status, because while DACA is currently in effect, in that people that currently have DACA can renew their DACA. Someone that has not previously had DACA or had DACA that expired more than a year ago, which is considered a new application, the government can accept those applications, so you can send them in with the fees, but they will not be processed. We will not have decisions, and that's because of all of the pending litigation around DACA and the future of the program. So that said, what's the current state of litigation? Texas and several other states sued the US government to stop DACA, arguing that the program essentially was executive overreach because DACA is not something that's explicitly provided by statute, right? It's something that came down through executive order, and that there's been subsequent attempts to fix to make it stay slightly more.
And I would say like the most generous interpretation of their argument is that DACA is creating a new type of immigration relief that can only be done through a law, right? That Congress has to pass a new law to protect these people. So their argument would be, we don't hate immigrants, we don't hate dreamers, we just think that Congress needs to create a program to provide them lawful status.
Yeah, and so what they've tried to do, so initially DACA came down through executive order, And then the Biden administration, in an attempt to strengthen DACA, tried creating a new regulation, which is different than law because it does not go through Congress. It's, again, something that's created by the executive, but it does have a comment period and a notice period. So it's, slightly more process and like more foundation to ground it in. But there's still ongoing litigation. And really the reason that we're bringing this up now, besides we think that it's relevant what's happening with DACA, is that there may very well be some movement next month or shortly thereafter, because on June 1st, Judge Andrew Cannon, in the federal district judge, has oral arguments scheduled to consider the legality of the program, given these regulations that the Biden administration put forward. I think we are concerned about the possible outcome because in 2021, this same judge had already ruled that the prior way that they tried to implement or start DACA was unlawful, and that was done via memo. It wasn't done via regulations, but essentially it was identical.
Right. So I think most advocates are not super hopeful that Judge Hainan is going to change his mind, despite the attempts by the Biden administration to create more process around the program. If Judge Hainan again says that the program is unlawful, which we expect he will, the case will be appealed again to the Fifth Circuit. The Fifth Circuit last year also said they believe that the program is unlawful. So I don't think that anyone is super hopeful that they're going to change their mind. And the case will most likely go back to the Supreme Court, which could take a long time, which, we hope will take a long time, right? Because nobody is expecting good decisions. I think one other piece to flag about this is that the Department of Justice recently put out several requests to Judge Hainan. They seem sort of like begging him a little bit that if he was going to, again, say that the program was illegal, to limit the scope of his decision. So either to allow the federal government to unwind the program over a period of time, or to limit the decision to just people who live in Texas, because Texas is the only state that has claimed to have an injury from the program, a financial injury from the program. And in fact, New Jersey was one of the states that initially stepped forward to defend the program and to speak up about all of the benefits that our state gets from the program. So the government is trying to do whatever they can to continue to protect the program, but at the end of the day, it seems pretty clear that DACA has been going through like a long, slow, painful death, which I don't say flippantly, right? It's been incredibly stressful and painful for people who are DACA recipients who have built their lives around the fact that they have work authorization, that they're not living day to day afraid that they're going to be deported, and to now have for the past, since essentially 2017, live with the stress of not knowing how long the program is going to continue, really underscores the point that the DACA program was never enough. Mm-hmm. It was an incredible organizing victory when young people came forward and essentially demanded that President Obama create a program to protect them when Congress didn't act. However, it was never a sufficient or strong enough protection. And I think that continues to be very, very clear as we see what's happening with the litigation.
And just like, Lauren said it very well, but just we don't know what this decision or the aftermath would look like, if it will limit to Texas, if it will be a wind down, what that wind down would be, whether it be that whoever has a work permit now can continue to use it until it expires, whether there'd been like a final renewal period where people could apply before X date and have it granted one last time, whether there'd be some form of grandfathering. We don't know what that wind down would be. And so we can't actually provide direct guidance on act in such way to best preserve your rights. What I can say is that we are, for our clients, recommending that if you would be reapplying now or very soon to renew your DACA anyways, that you submit that application. And On that fun note, one thing that I realized we did not have a slide for, but I do want to bring up, just because I think this is something that you may hear from students, is there have been recent changes to the way that special immigrant juvenile status visas are becoming available. So special immigrant juvenile status is a route to a green card for a child that has been abused, neglected, abandoned, or similar basis by one or both parents. And that program is still the same. The legal requirements of the program are still the same. Nothing has changed, but what has changed is the way they're calculating visa availability. So previously, there was a wait list for children from the Northern Triangle and Mexico, primarily among the clients that we see, which is largely Latin American Spanish speaking. They have that changed a little while ago, that there was a wait list then for everybody, but the Northern Triangle and Mexico had a much longer wait list. And then just recently they reassessed how they're calculating visa availability, and now worldwide visa availability for SIDGE is the same. So children that would previously have had no wait or a very short wait to get the green card through that special immigrant juvenile visa now do have a wait that is accompanied by a change from, I think, last year. Can't remember what month it happened, where they also now, with an approved special immigrant juvenile visa petition, while you're waiting for that green card to become available, can be granted deferred action and get a work permit, and that does last 4 years, which is a large benefit compared to what was had previously. So it's kind of mixed news in terms of what it means for children applying for SIDGE, special immigrant juvenile status, and their rights and their ability to work and have protection from deportation while they're waiting for a visa to become available.
And so the wait list right now, they're able to approve green card applications for young people who had submitted their applications before, I think it's like September or October of 2018. So it is a significant wait list. As Ariel said, the work permit and deferred action is very helpful. Some of the limitations are that those young people are not eligible for financial aid, for federal financial aid. So many of them want to go to college and they're limited in that. It limits their abilities around getting married and starting their families. So it's still, I know Ariel's saying it's not entirely true, but they can't petition if they don't have their green card. They can't petition for other family members. So there still are significant limitations to not getting the green card. Two other very quick updates that we'll mention that we forgot. There's been so much that's happened since we last spoke a year ago. So one, hopefully many of you have seen, New Jersey passed a policy called Cover All Kids that expanded healthcare eligibility in the state. So for New Jersey family care to all children under the age of 19, right? So all children up until 18 are eligible for healthcare in New Jersey, which is a huge victory. They apply much the same way they do for, that citizen children or other children with status have applied for Medicaid. We've been helping a lot of folks apply. People are really, really excited. And then the last healthcare update is that the federal government changed the rules around eligibility for marketplace coverage to include individuals who have DACA. So previously, DACA recipients were only eligible for health insurance if they got it privately or through their employer. But now DACA recipients are able to purchase coverage on the exchange, which again really expands access to healthcare to a large group of people. I'm sure there's more that we're forgetting, but we're going to stop now to get to some of your questions.
And so, okay, if you give us...
And I apologize too, we had said at the outset, we're talking to teachers. We should really make it interactive and not just talk at you for 45 minutes. And then we went ahead and talked at you for 45 minutes. So our apologies. We're lawyers, not teachers.
Yeah. You get paid to talk, not to listen.
That's right.
So
but it was great information. I'm sorry.
Yeah. So I think, some of the questions you may be able to synthesize, like there was sort of a few questions about work, and also there was questions about Haiti, sort of an update on Haiti and Ukraine and things like that.
Yeah, so I'll take the work permit question really quickly. Lauren, then if I'm missing something. So essentially, yes, like someone is not legally authorized to work in the US unless they have a work permit. That does not mean that people do not work without work permits. I think what I always message to my clients is that using someone else's social security number is a dangerous thing to do if you're working without authorization, and as well that saying that you're a US citizen when applying for that work also has long-term consequences with immigration. So it's something that really should be avoided. There are occupational licenses that are available without need to have a work permit. So that's something that's important to note. And the other is that even if you are working without a work permit, you are legally required to be paying taxes, and that is done through an I-10. An I-10 is an identification number that I consider similar to a social security number, and that's used as on your tax returns to pay your taxes. Working without authorization in a lot of instances does not prejudice long-term immigration relief. In certain instances, it can. So it's really important that that individual talk to an attorney about their specific case and possibilities to see if that's something that could affect them or not.
So that's exactly what I was going to say. The only thing I would add is that, so Ariel mentioned the occupational licenses, which are, a really incredible tool for people who are not work authorized. They do not automatically give someone the ability to be an employee, right? Which is what the law really prevents. But if folks are able to set up an LLC or start their own company and they're able to get an occupational license, it does give them many more opportunities to work and support themselves and their families, right? So the prohibition is that you can't be hired as an employee under federal law, but it doesn't say that you can't work or that you can't earn money. And so I think the trick for folks who don't want to work without authorization is to find ways to work not as employees. And there are some good resources available online. And I think that some of the law firms might have clinics available if for like small business owners who are starting up and need help establishing an LLC.
The other thing that I do want us to state and make really clear, because I hear about it a lot, is that when an individual is not employment authorized, a lot of times the employer abuses that situation by not paying the employee what they should, by the conditions they're working in, by threats made to the employee to control what they're doing. There's a lot that can happen when there's that really difference in power dynamic. Just because you're not employment authorized does not mean you do not have rights in the workplace. And you can see that through this DALL program that we're talking about. So people should not be afraid to come forward and report or sue on employment abuses just because they're not work authorized.
So with regards to the DALL program, there was a question about where does it start? Do people start with the DOL or where do they start?
Yeah, so if someone has suffered a labor rights violation or witnessed a labor rights violation, they should, I would say, first thing is talk to an employment lawyer if they can. And the employment lawyer or like a workers center or workers rights organization can help them file a complaint with the appropriate authority, right? It could be with the Department of Labor, either the State Department of Labor or the federal one. And I know we've had a lot of conversations with the Department of Labor here in New Jersey, and they are very, very eager to support workers in this posture, right? They've really been doing all of their research and figuring out what their processes are going to be to support workers in this way. If an individual is involved in a union campaign or is part of a union, they can talk to the union reps who may be interested in filing the complaint with the National Labor Relations Board, right? They handle all of the complaints regarding unionization and unfair labor practices in that context. They cannot apply for DALL without this letter of support from the investigative agency. And where it gets a little bit tricky, and again, because it's new, we don't totally know how it's going to play out. There are many labor violations that the agencies don't choose to pick up and investigate, right? Because it's one person or it happened a long time ago or is outside the statute of limitations, or whatever the limitation may be, the agency is not always investigating. And my sense is that they're not going to provide these letters of support if they're not actively investigating the case. Which is not to say that people shouldn't report it. If someone has a labor violation, they should absolutely feel safe going forward and reporting to the appropriate labor agencies, but it may not necessarily put them on a path towards DALE.
And the other thing, just to mark, and this really is very detail specific, and so I don't want to go into a lot of details on it, but to flag as encouraging people to come forward and at the very least speak to an attorney, is that certain employment violations beyond this possibility of DALE do give route to something called a U visa or a T visa, a U visa being a visa for victims of certain crimes, and a T visa being a visa for victims of certain forms of trafficking. Labor trafficking being one of them, which is a much, I think, broader definition than a lot of people consider it to be. So not every employment violation would give route to those visas, but some could. So it's important to reach out to an attorney, talk about it. And the benefit of the U or the T over DALE, for example, is that it's a visa that lasts 4 years and gives a right then to apply for a green card and later citizenship if the person wants to.
So to follow up on these employment issues, Zoe had a question about the occupational licenses. So is there a really good place to give students information, you know, in addition to or instead of starting with a lawyer about how it would apply to them?
So about the occupational licenses, let me check with our folks who are doing that campaign, and we can send it out to everyone after. The Department of Community Affairs, right? They're the ones who manage all the licensure, but we may have some resources that would be helpful for you all to share. So
Okay.
I'm going to make a note that we'll get back to that.
Okay. And there was a couple of questions about Haiti. You know, currently conditions are still unstable and not great. So any update on immigration policies with regards to Haitians?
So Haitians, they TPS eligibility, it's been the country designated for TPS, as well as, like we said, both this parole process and potentially family reunification process.
And we should say, you know, in full disclosure, the vast majority of our clients are from Latin America, and so we don't see a lot of Haitians or Ukrainians. But we can certainly refer folks to legal service providers who are providing those resources. But as Ariel said, for people who are here, there's the option to apply for TPS or to renew TPS, which is temporary protected status. I would say it's similar to deferred action in that you get a certain period of protection and the opportunity to apply for a work permit. But in terms of its basis in the law, it's a little bit stronger and more protected. And then there is the parole process, which, you know, we mentioned earlier, basically for people who have a family member here who has some form of status, which could include temporary protected status, they would have to sign this sponsorship form to say that they're going to support the family members when they get here. I know that there was a question about like, why are families still separated? I wish we had an answer to that. I think the answer is because our government is cruel and we don't have good programs or good processes. So yeah, there are many more opportunities for Haitians and Ukrainians to apply, to come to the US to apply for family members. And they've had those programs in place, those parole programs in place for a longer period of time. But we don't have a lot of personal experience with how they're working or what the issues are that people are seeing.
Okay, there was a question from Christian about the 200 plus certifications for undocumented immigrants. Christian, do you want to expand on that question?
Yeah.
Maybe I misheard, but at some point earlier on your presentation, you were talking about certifications that could be given or obtained by undocumented immigrants.
Yeah, so thank you. So this was something that I learned as our young people actually led us in the campaign for occupational licenses. In New Jersey, there are over 200 jobs that require a certification. You did hear me correctly. I just forgot what I said. So that's everything from teachers to nail technicians to electricians and plumbers and nurses and all sorts of different professions that need to get a license from a state agency in order to practice their profession. Previously, there was this very complicated mix of requirements. So some of the licenses explicitly said you have to be a citizen to apply. Some of them didn't say it, but they might say you have to show this proof. You have to show your birth certificate or your passport. Some of them said you had to provide a social security number. Others of them may not have said it in the requirements, but the application form might have a spot where it says you have to give your social security number and there's no option to not give it. So it was a really complicated morass of different rules and requirements. The law is very simple and says that for those professional licenses, you do not have to show that you are a citizen or have another form of lawful status. So it opens the door for many immigrant community members to get these professional licenses, but they still have to show they have the appropriate training, they've taken the appropriate classes, they've passed the appropriate tests, all of those other requirements. And I think that the implementation process of figuring out how to untangle the previous complicated different rules that might be different in this place or that place has been longer than we might want. But if you have students who are interested in any of those professions, I would absolutely encourage them to explore what options are available to them.
I mean, to me, what's most interesting about that is that on the surface, you're like, well, if I can't be an employee, what does that do for me? But we actually know that in the immigrant community, there's actually a higher rate of entrepreneurship. Right? And so people do create their own businesses and, and end up working for themselves. So I think it actually, it does provide some opportunities that weren't there before. So in the chat, I've dropped the link for those of you that need the PD certificate for this session. So please click on that and fill out the survey. I'll get the PDF of the slides from Lauren and Ariel, and I'll send it out to folks after the session is over. So Lauren and Ariel, any last words as we're wrapping up?
I think the only last words that I have, and this is coming very explicitly from my role as a lawyer, is that immigration is confusing. It's a lot. There's, I think, especially in the past 7 years, constant changes. A lot of times people are not aware of relief that they may be eligible for. So I think for me, just telling people the starting point is always like, if you don't have lawful status, the starting point is always to ask an attorney, consult with an attorney, see if there is some relief available to you and what that is. And to remember that may change. Just because you're not relief eligible today does not mean in 2 years you may not be. So just being really open to asking and coming forward, because the longer you wait, a lot of times the harder it is if you're actually eligible for something.
Yeah, I would agree with that. And just to thank you all for everything that you do, right? Like, you create a safe space for your students where they do really feel comfortable coming forward and getting information. A lot of people don't like lawyers, but everybody loves teachers. So we're super grateful for you all and for your partnership and all that you do to make sure that your students are getting access to accurate information. There's a ton of misinformation and confusion. And so, we appreciate you, and we can also share with Eric our contact information. If folks have questions, definitely reach out.
Excuse me, can you re-show the link for the certificate?
I'll drop it in the chat again. Yes.
Okay, thank you.
Yeah.
It was in the chat.
Yeah, it's the chat. I think to that point, Lauren, I think that, or to both of you, because it is so confusing, right? As teachers, we're not in a position to be able to answer these questions, right? But we're certainly in a position to encourage students to apply for all that they're eligible for, right? And we know across the board, whether it's immigration, other social welfare services, people actually don't apply for everything that they're eligible for, right? Whether it's, food stamps, whether it's, unemployment, right? And so certainly we're in the position of trying to encourage people to take advantage of things that they've paid taxes for, right? And they have a right to, right? So I think that even if we can't answer some of the complicated questions, we can encourage them and try to get them connected to resources. So, all right. So thank you for all this information. We'll be sending that out to folks again. I'm going to drop the PD certificate information in there again. And certainly everybody keep an eye on Make the Road New Jersey. As a proud member of Make the Road New Jersey, keep your eye on Make the Road New Jersey. So, and as a sales pitch on Saturday, the last session, I'm going to be talking about work that I've done with my English class at Make the Road about combining students' advocacy goals with English writing practice. So it's certainly connected that way. All right. Well, thanks, Ariel and Lauren, for your time. And thanks everybody else for coming to this first session of the conference. We're off and running now.